Soon, two murder suspects will be getting out of jail after taking a plea deal to lesser charges. Marquise Smith and Tychicus Doby were accused of shooting and killing Kendal Crank, a mother of two 6 years ago. Crank was caught in the crossfire of two groups who were firing at one another from their cars. Records show Smith and Doby did not fire a weapon. A third person in the vehicle with them did, Adonis Smith.
Joining us now, our chief legal analyst, Khalif Rhodes. Khalif, can you kind of take us behind the scenes, behind the curtain about how this all works there? I mean, these young men have been in jail for, 6 years now since the crime happened, so they're almost done with what they would face with this deal. But working out a plea deal at this point, is this because Adonis had a hung jury and they're trying to get Adonis? What's the inner workings here?
So I had the opportunity to talk to one of the attorneys for the case, and you're right on it. So they were prepping to go to trial this month. That you get a trial calendar, your name is on the trial calendar. You've been prepping for the last couple of months to actually go to trial, and then all of a sudden the negotiations open back up with the DA's office, and having that opportunity to negotiate something like this is I won't say it's rare, but it does happen, where for a number of months there's no conversation with the DA's office, and then there may be an initial offer, and then after that it's kind of silence. And then it's like, all right, your client will either accept or reject an offer and get on the trial calendar. And that's what happened. These people were on the trial calendar, and then all of a sudden, Adonis has his trial, and then the trial calendar is still set for this month, and then negotiations open back up. That part the attorney didn't share, but I would speculate that that's exactly how we got to this point here, specifically for a number of reasons. You get to that trial calendar, there's maybe 6 or 7 folks in that room. I was one of those folks on that list. I'm way down the list, thankfully, so my trial date didn't come up and it got pushed, but I'm on that list, and you're looking like, okay, if I'm 1, am I 2, where am I at? Meaning, am I going to have to go to trial, or am I going to get bumped for another time? You can see your name up there, and you're ready by that moment. You're not showing up that day saying, okay, now I'm going to get prepared. You've already have been preparing for this moment. And so something like that, I think a number of things play into part time. The facts of the case, getting an investigator to actually see what the allegations are, what the prosecutors are alleging versus what your investigator is alleging, and then allowing yourself to have that communication with the DA and say, hey, this is what we'd say at trial. We think that we have a significant difference in facts and timeline, and because we're going to be pointing to a different direction, I want you to know what you're walking into. Sometimes sharing that with folks allow the negotiations to open up as well.
Sometimes you have grieving parents, grieving families say that a plea deal is like a get-out-of-jail-free card. Does the law, does the court, do they take victims' comments and concerns into consideration when these deals are being made?
Absolutely. So Mecklenburg County, and I can speak for here and other counties that I go to, but Mecklenburg specifically, the DA Meriwether and their team do an excellent job of ensuring that they have victims assistants that work and talk with the families directly, that walk lock and step with them from the time they first meet with the DA's office to the time that they get to court. So when they get to court for a plea deal or for some bond hearing or something like that, that victim assistance is walking them around the building literally to location to location, and so then when it's time for them to speak, they're speaking. But you will hear the DA say, I've spoken to the family about the plea, and I've made sure that the family is on board with the plea. Most of the time they will say the family is on board with the plea. In situations like this, the family was not on board, and it seemed like it was something that they were not okay with. But I think I go back to my first statement, which is this is more fact dependent. We already had a trial before. We saw where that trial ended up with the hung jury. That person actually pulled the trigger. Now you have 2 individuals that didn't even pull the trigger, that were not connected, and you're going to say that it probably will be a worse outcome, which would be maybe a not guilty. So do you want to put the family do that again? Obviously the worst situation ever to have the loss of life, and I could 100% understand and appreciate how the family feels let down in that situation. But I think that there's oftentimes more that's happening behind the scenes, and the family's getting as much as they can get, but you also can't walk them through how the rules of evidence work, what certain things will come in, how you'll be able to convict and get past that burden, which is beyond a reasonable doubt. And if the DA thinks they can't get beyond that burden, but they can get something, they're going to try to get something.
Well, I mean, I think you kind of broke it down there. It's just like this is our best possible outcome to reach some sort of resolution, is to do this given how Adonis's trial worked out. I do want to ask you, though, because we're talking about, again, 6 years that this family has been waiting for closure. I know there was a backlog during the pandemic in court cases, but for, the average person watching at home, doesn't that seem like a very long time
to
wait for the wheels of justice to turn?
Wheels of justice turn slow. Mecklenburg County, the largest in terms of folks that come through our system in our state. And so when I sit down with a homicide suspect, I tell my clients, listen, the lifespan is 3 to 5 years from the time you talk to me today to any outcome. That's plea, that's dismissal or trial. So 6 years is with a little bit outside of that scope, but that's about the normal because this takes a lot to get through these cases. So Chief Justice of the Supreme Court of North Carolina is attempting to speed those up, but you can't speed up a backlog. So we're still trying cases from 2021.
Forget a right to a speedy trial, right?
There's a constitutional right, but we have no speedy trial statute in our state. And so as long as you're following the plan of the trial court administrator, then you are constitutionally protected.
Whew, man, it's hard, yeah, when you're the family of the victim. All right, Khalif, thank you. Appreciate that.
Queen City News Plus. Just search Queen City News on your smart TV's app store.